Okay, welcome everybody. This is a supplemental video for Unit Week 6. It's to supplement your reading in Chapter 10 of your textbook, which is entitled Bias in and Out of the Courtroom. So a lot of what we're going to go through, the rules, are both from the ABA model rules and the canon for judicial conduct as well. And these rules apply to the discussion problems and the multiple choice questions, and maybe some of them are found in your reading as well. So let's begin. All right, this is a fairly new rule, or let's put it this way, I think the rule has been modified to include sexual orientation and gender identity. And I think that change has been done sometime in the past 5 to 6 years. And last I remember, only 3 or 4 states have actually adopted this rule. Probably more will adopt it. Probably most states will eventually adopt it with the craziness going on about gender identity and things like now, especially in the United States. So this rule has to do with misconduct, and it has to do with bias or discrimination or harassment by an attorney. So it says an attorney shall not engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. So that's key. They cannot participate in harassment, discrimination, or bias based on certain characteristics in conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from representation in accordance with Rule 116. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. Okay, so that what has been added is sexual orientation and gender identity. You can't discriminate, harass, be biased in conduct related to the practice of law. Well, what does that mean? Conduct related to the practice of law. Well, it's pretty open-ended, and you'll see from one of the comments that has attached to 8.4G. So comment 3, it says, discrimination, harassment by lawyers in violation of this paragraph undermine confidence in the legal profession and the legal system. Such discrimination includes harmful verbal or physical conduct that manifests bias or prejudice towards other. Okay, so what is harmful verbal conduct? Words are not conduct. See, one of the things that what you'll see over in the United States right now is that there's a saying, your speech is violence while my violence is speech. So people who don't agree with certain shibboleths that are going on in the United States right now, and if they voice that disagreement, well, they're considered violent. But if you burn down a city or loot a business or riot because of a certain for a certain reason that the mainstream media and the system over here wants to promote, then that violence that you're committing, well, that's actually just speech. Okay, so just to let you know what's going on over here. So harmful verbal conduct. Speech is not conduct; it's speech. Okay, and what does it mean to manifest a bias or prejudice towards other? How do you know there's a bias? Who gets to determine that? Is it based upon the actual speech, Or is it based upon the perception of the person who heard the speech? Well, here's the hint. Depending upon which side of the certain protective classes you fall on, it's perception. All right? All right, so harassment includes sexual harassment and derogatory or demeaning verbal or physical conduct. Again, verbal conduct. There's no such thing as verbal conduct. Okay? Speech is not conduct. Sexual harassment includes unwelcome sexual advances, requests for sexual favors, and other unwelcome verbal or physical conduct of a sexual nature. Now, some of this is very straightforward. Okay, so if you make an unwelcome sexual advance, if you touch someone inappropriately, if you are a boss somewhere and you request sexual favors from one of your underlings, that's pretty straightforward and really is not problematic. What becomes problematic is when someone says, well, there's been some unwelcome verbal conduct of a sexual nature when, for example, someone says to a woman, that is a very nice dress you're wearing today, you look very lovely. Is that sexual harassment? Well, or is that just a compliment? Well, it can be construed as sexual harassment because they say, well, you wouldn't tell a male coworker that they look nice today. And actually, maybe you would. Okay? So there's a lot of gray areas that are in this rule that are open to a lot of interpretation, and thus will bring a lot of problems that don't have to be there. And like I said, if it's clear that you are discriminating, that you're prejudiced, biased against someone based upon your conduct, how you've treated them, or what you have said to them, that's fine. But then we get into these gray areas where people start to interpret things, and it's up to the one who perceived it. And if you are a person of a certain color, it doesn't matter whether you did not mean to be discriminatory, prejudiced, or biased. They're just going to say, well, because of your color, you're inherently biased. And that's what's going on over here now. So this rule is rife for abuse. That's what I'm trying to tell you. It's not as straightforward as they think it is. And in fact, the people who wrote this wanted to create a lot of mischief with this rule, and they wanted to create a lot of problems, and they want to silence a lot of people. Number 4, again, this is comment 4. It says conduct related to practice of law includes representing clients. So let's go back again. So this is about discrimination, harassment, or bias in conduct related to the practice of law. Okay? So this is what conduct related to practice of law is. It includes representing clients. Okay, fine. Interacting with witnesses, co-workers while you're at work, court personnel, okay, while you're in court, lawyers and others while engaged in the practice of law, operating or managing a law firm or law practice, and participating in bar association. Okay, is that the conduct of law? Well, they say it is. Business or social activities in connection with the practice of law. What does that mean? All right, lawyers may engage in conduct undertaken to promote diversity. Okay, let's stop. It says business or social activities in connection with the practice of law. Suppose you go to a pro-life legal event that is a dinner. It's a social activity. So are you showing bias? What about if you're going to a pro-biblical marriage event? Are you showing bias and discrimination and harassment? Those who wrote this law would say yes. Hopefully, cooler heads would prevail. Okay. Now, for example, in your multiple choice questions, there was a question about a couple of guys at dinner together. They worked at the same law firm, but they were not at work, and they were talking about a gay employee and not using the greatest language or whatever to describe that employee. Well, that was not considered conduct related to the practice of law, even though they were lawyers that worked at the same firm. They were out to dinner, they weren't on firm business, they weren't in the office, so therefore that was not considered conduct related to the practice of law. However, there are bias and prejudice and discrimination that is okay when it comes to these rules, and this is how they describe. They say lawyers may engage in conduct undertaken to promote diversity and inclusion. Okay, so they're key buzzwords that you can be biased, you can discriminate if you're doing it for diversity and inclusion. Okay, what does that mean? That means that you can favor certain groups of people, okay, over others, if it promotes diversity and inclusion. Now, what does diversity and inclusion mean? Diversity and inclusion means anything but white people or white men, okay? White straight men, okay? It means gay men, it means lesbians, it means transgender, it means black, it means indigenous people, it means so-called people of color. That's what diversity means, okay? So, if, for example, I was at a law firm and there weren't any other Irish people of Irish ancestry at the firm, and I wanted to recruit some other people of Irish ancestry because they were underrepresented in the firm, well, I probably wouldn't be able to do that because people of Irish ancestry are considered white, and therefore that wouldn't promote diversity or inclusion. Okay, so you can implement initiatives aimed at recruiting, hiring, retaining, and advancing diverse employees or sponsor diverse law student organizations. Remember, diversity means not white, and especially not white male. All right? These are just the facts. This is what is going on in the United States right now. This is why very possibly soon there's going to be a revolution over here. Hopefully not. Hopefully we can get past this bitterness and this idiocy and this dividing of people based on the color of their skin and all other things. But right now, it doesn't look good. Okay. Number 5, it goes to peremptory challenges. That is in the voir dire stage when you're picking a jury, and this has to do with peremptory challenges. Peremptory challenges, if you go into a civil trial or even a criminal trial, you bring a jury pool in. Depending upon the jurisdiction, you have so many number of peremptory challenges concerning those who can sit on the jury. Peremptory challenge means is you can dismiss them for no reason at all. Okay, so say you have a bad feeling about someone and say this won't be good for our client, they won't be fair, this person doesn't seem like a good person. It's just based on a feeling. Well, you can use a peremptory challenge to just get rid of them. Okay, and the judge will allow you, or the court will allow you 3, 4, 5, depending upon the jurisdiction. However, these peremptory challenges can't be used based upon any type of discrimination. Okay, and that's what they're saying here. All right. Okay, let's go to conflict of interest, current client specific rules. This has to do with question 3 in the multiple choice questions. Specifically, it says 1.8J, it says a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. So, if it's a new client and you're not in a sexual relationship with them, no sex. However, as you saw in the question, you could date them. Okay, so you could enter into a dating relationship with them, but no sex. Now, of course, if you are in a sexual relationship and they become your client, that's okay. Comment 19, it says when the client is an organization, so it's not just a person, but it's an organization. So say you are representing a business. Paragraph J of this rule prohibits a lawyer for the organization. So that's a lawyer who works for the organization you're representing, whether inside counsel or outside counsel, from having a sexual relationship with a constituent of the organization who supervises, directs, or regularly consults with that lawyer concerning the organization's legal matters. So you can't have sex with that person if they are involved in your legal representation, okay, unless you've already have entered into a sexual relationship prior to you representing that organization. However, if there's somebody in that organization who doesn't deal with you or interact with you concerning the legal representation, then you can have a romantic relationship with them. Whoops, what the heck? Okay. Fairness to opposing party and counsel. This is 3.4e. And this has to do with multiple choice question 4. And also in your discussion problems in the beginning, it had to do with discussion question 2 and the old coot. Okay? It says a lawyer shall not in trial allude to any matter that the lawyer does not reasonably believe is relevant. Okay, so you can't just throw irrelevant stuff into the trial. You have to believe it's relevant. Or that it will eventually be supported by admissible evidence. So you can't bring a fact in to trial that is not supported by admissible evidence or won't eventually be supported by admissible evidence. Okay? You can't assert personal knowledge of facts. You're not a witness. Okay? You're not a source of facts. You are an advocate. Okay? Unless you are testifying as a witness. Okay? Or you cannot state a personal opinion as to the justness of the cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. So what it's saying is you can't just go up to a person who's accused of a crime and you're a prosecutor and say, you're guilty, I know you're guilty. What your job is to marshal the evidence to convince the jury that that person's guilty without you ever having to say or make that claim that they're guilty. Okay, now, the jury's going to know that you think that person's guilty. Still, you can't say it. Okay? You can't make a statement that the witness is not credible. You can ask questions, and you can question the credibility or veracity of a witness so that you can convince the jury that the witness isn't credible, but you can't just say, hey, you're a liar. You can say things like, didn't you say something different in your deposition? Or didn't you say something different to the police officer when they took your statement? Okay? Which is basically saying you're a liar, but it's using facts to imply that and not saying that. Okay? So, for example, in question number 4, the multiple choice questions, when the attorney was asking the witness whether that they were a lesbian based upon the fact that that person was 31, never married, and they were unattractive. Okay, is that relevant? Okay, is that supported by admissible evidence? I say it might in that fact. The answer was that the attorney would be subject to discipline, but my question is, well, what if this is a sexual harassment case, and the employer, the homeowner who employed the woman, if he knew she was a lesbian and knew she wouldn't come on to his attempts to have sex with her or whatever, his come-ons to her, then I think it might be relevant to say, well, are you a lesbian? Yeah, well, he knew you were, so why would he bother? Okay? So it's not quite as straightforward, I think, as that question leads us to. And then there's also where after questioning the older gentleman who was in the car accident, the person says the state needs to do a better job of keeping old coots off the highway. That's not relevant. You're basically calling the witness a name. It's not just. So it's not fair to opposing party. Okay. Okay, impartiality and decorum of the tribunal. A lawyer shall not engage in conduct intended to disrupt a tribunal. Okay, the advocate's function is to present evidence and arguments so that the cause may be decided according to law. Again, as an attorney, you're not supposed to be emotional. You're not supposed to get overheated and overwrought. Of course, you can make your point by, acting out things or raising your voice or whatever. However, you need to refrain from abusive or obstreperous conduct. Or refraining from abusive conduct is a corollary of the advocate's right to speak on behalf of litigants. Okay? What that's saying is you're not in there raving and ranting. Okay? That's not what you should be doing. You should be advocating for your litigant through well-crafted argument, well-crafted use of the evidence, and well-crafted use of the law. Okay, here we get one thing. I don't know if you guys remember, but in your oral advocacy class, at least when I taught it, I always said that the judge does not have a right to abuse you during your argument or belittle you. Okay, so this is saying a lawyer may stand firm against abuse by a judge. Okay, because that could happen. You could be subject to abuse by a judge. But as the Lord says, vengeance is mine, you're not to return that abuse. And it says you should avoid reciprocation. The judge's default is no justification for similar dereliction by an advocate. So don't repay evil with evil. Okay, that's what the Bible says, and that's what this says. If the judge is acting evil, if he's acting abusive, if she's acting abusive, don't act evil back. Okay, you have a way forward. Okay, it says an advocate can present the cause, protect the record, so you protect your record for subsequent review, and preserve professional integrity by patient firmness no less effectively than by belligerence or theatrics. So basically what it's saying is do your job, be professional, preserve the record, so that way once the trial's over or the hearing's over or whatever is over, if the judge acted in an abusive manner, you have that record to go on, and then you can go seek justice against that judge. All right, either reporting that judge to its board, the Board of Ethics for that jurisdiction. If the judge was abusive, you can get the trial overturned. You can win on appeal, things like that. Okay, so basically what this is saying, the judge is evil, don't repay the judge with evil. Do your job. The duty to refrain from disruptive conduct applies to any proceeding of a tribunal, including a deposition. A lot of attorneys think, well, the judge isn't here, okay, if they're not in the tribunal, if they're not in the courtroom, so my behavior doesn't really matter. Yes, it does. It matters at all times when you're practicing your craft, when you're practicing the law. I've sat in on a bunch of depositions, and I've seen just terrible behavior by some of the attorneys, and they do it because, well, they think they can. They're outside the eyes of the judge, and they think, well, I'll just do it and I'll get away with it. And no, you won't. Okay. Okay. So 4.4, it says respect for rights of third persons. This also has to do with the number 4, question number 4, multiple choice question 4, and the questioning about whether the woman was a lesbian, and also when it comes to the old coot discussion problem. It says, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. So think about that. You're asking, you mentioned that someone's an old coot. Okay, well, that's embarrassing the other party. Okay, to delay or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. Okay, so now we go to Model Code of Judicial Conduct and Canon 1. This Chapter 10 asks you questions concerning judges, and your reading material really doesn't include much that concerns judges, so this part's a little bit longer. So Canon 1 is: a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. So this is key. A judge needs to be seen as fair and unbiased, independent of any external or internal pressures. Okay, they have to be in integrity, meaning they have to apply the law, they have to apply their profession in a straightforward manner, and they have to be impartial. And these are all biblical concepts, quite frankly, for a judge. Okay, this is straight out of the Bible. And also the appearance of impropriety. So the judges have a very high standard to meet. Not only actions of impropriety, but any type of appearance of impropriety, and that affects them outside of the courtroom as well. Okay, Rule 1.2, promoting confidence in the judiciary, says the judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Okay, comment 5. So actual improprieties include violations of law, court rules, or provisions of the code. So these are actual improprieties. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, impartiality, temperament, or fitness to serve as a judge. So that's the appearance. Okay? So is in a reasonable mind, is there a perception that the judge is not impartial, that the judge does not have the right temperament or is fit to serve as a judge? Okay? So it's not just actions or actual improprieties, but it's appearances as well. Okay, now we go to Model Code of Judicial Conduct, Canon 2. It says a judge shall perform the duties of judicial office impartially, competently, and diligently. Okay, judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. To ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Okay, I would say they need to be objective to the parties and open-minded to the parties. Okay, this doesn't mean that you have to be open-minded in your worldview or in your judicial philosophy. So, for example, Justice Clarence Thomas, he's not open-minded when it comes to his judicial philosophy concerning how he interprets the Constitution. That's not what it's saying, okay? But you need to be objective and open-minded when the parties come before you. Comment 2, although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. Okay, so they each come with a unique background and personal philosophy, but each judge also comes to the bench with a judicial philosophy as well. Like I mentioned, Justice Thomas has a specific philosophy when he interprets the Constitution, just as Justice Kagan, who's considered more of a left-wing associate justice, she has a judicial philosophy. There's no denying that. And basically, they're the opposite of each other. Justice Thomas and Justice Kagan, they're basically the opposite of each other. Even compared to, say, Justice Gorsuch, who's more of a libertarian, he has a different philosophy than Justice Thomas does. Okay? So we're not talking about judicial philosophy. Okay? We're talking about background and personal philosophy. Personal philosophy could be your religious beliefs, I guess. Or it could be that you're a communist, okay, which is a personal philosophy. all right, or you're a capitalist. Okay? But a judge is supposed to be impartial. They must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. So, suppose a judge has to apply a law, and they don't agree with the law. Well, that's not up to them. The legislature creates the law, not the judge. Okay, even though many judges think they do. All right, Rule 2.3 when it comes to the judiciary: bias, prejudice, and harassment. It says a judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. Great. Okay, so we're back to that. What does that mean? A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice or engage in harassment, including but not limited to bias, prejudice, or harassment based upon sex, race, gender, religion, national origin, ethnicity, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation. Notice there's no gender orientation in there yet. I'm sure that'll get, it's not in there by now, it'll be in there soon. Okay, and shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. So the judge can't do it, and people in his courtroom can't do it as well. And this goes into question number 2 in your multiple choices when it comes to the question about the person who was confined in a wheelchair, and he approaches the bench and he wants the judge to come down, and the judge says something like, this is my court. If you insist on practicing law, you're going to have to accommodate yourself to me. Okay? Well, the question to that is that the judge reflects bias. He reflected bias against disability. The person was in the wheelchair. Also, in your discussion problems, question 2B, the judge kept referring to the woman as Missy. That's a little bit degrading unless that's actually her name, but usually the judges don't refer to you by your name. So you could say that is sex. Oh, they do have gender in there. Sorry. Sex, discrimination based on sex. Okay, so a judge shall require lawyers in proceedings before the court to refrain from manifesting bias or prejudice or engaging in harassment based upon attributes including all the above listed. Okay, so the judge is responsible for whether the lawyers act in a biased, prejudice, or harassing manner as well. Okay, a judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. No one wants to go before a judge and feel as though the judge is biased against them or prejudiced against them, even though the judge very well could be. Okay, we are talking about human beings here. The thing that the judges, if you ever become a judge, that you have to understand is you are going to be prejudiced, you are going to be biased. We all are. It's being aware of those biases. It's being aware of those prejudices and overcoming them. Okay? That's what a good judge does. Nobody can be without prejudice. Nobody can be without bias. It's working to overcome them, to be aware of them. Okay, harassment as referred to in paragraphs B and C is verbal or physical conduct. Again, speech is not conduct, okay, but this is what they are insinuating into our law here, that speech is conduct. Why are they doing that? So that they can regulate it. Okay, the First Amendment basically does not allow government to regulate your speech, okay, but if they can turn speech into conduct, then they can regulate it. It says Congress shall make no law abridging the freedom of speech. Speech is not conduct, folks. It's insidious what they're trying to do. Okay, nonetheless, if your speech denigrates or shows hostility or aversion towards a person on basis such as race, sex, or gender, that shows bias, prejudice, or harassment. Okay, as well as any type of conduct that would do that. All right, disqualification. Okay, so when is a judge disqualified? A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. Okay, I want to notice Rule 2.11, it says, a judge shall qualify himself or herself. The way things are going in the United States right now, that is the gender binary, and this would be considered transphobic. Okay? It's ridiculous. Okay, but I just think it's hilarious, but it's not hilarious. It's actually quite frightening. I'm sure they'll change this pretty soon as well. Okay, the judge has a personal bias or prejudice concerning a party or party's lawyer or personal knowledge of facts that are in dispute in the proceeding. So they have to recuse themselves if they have some type of personal bias or prejudice concerning a party. That could be a bias favoring the person. Okay? If someone comes up, if your daughter comes before you, you're going to favor your daughter, right? So that's prejudice. Or if the judge actually knows facts that are in dispute in the proceeding, they have to recuse themselves because the judge might eventually become a witness in the trial. Okay, supervisory duties. So a judge shall require a court staff, court official, and others subject to the judge's direction and control to act in a manner consistent with the judge's obligations under this code. So whoever works in the judge's chamber, whoever works in the judge's courtroom, the judge has to supervise them when it comes to bias, prejudice, and harassment. A judge with supervisory authority for the performance of other judges shall take reasonable measures to ensure that those judges properly discharge their judicial responsibilities, including the prompt disposition of matters before them. Okay, so there are senior judges who are responsible for other judges within the jurisdiction. So, for example, in the Fourth Circuit, you have a number of circuit judges, and then you have the senior or head circuit judge who is a supervisory authority for all those other circuit judges. Okay, so that judge has to take reasonable measures to ensure that those discharge their judicial responsibilities, which includes no bias, no harassment, no discrimination, including the prompt disposition of matters before them. One of the things when I was a clerk, the head judge in our chambers was always worried about whether we were meeting our deadlines, our time frames, and whether we were bringing matters to a quick and equitable close. Okay, and that's one of the things that my judge was always worried about. He's saying he's going to come down here. He's going to want to know my schedule. He's going to want to know how well we are moving through our cases. So what I did was I provided a spreadsheet, or basically a spreadsheet with the status of our cases, so that my judge, when he was questioned on that, could either hand that spreadsheet to the head judge or just go through it with him. Okay, easy peasy. All right, Canon 3. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of judicial office. So this goes to the perception of the perception of a judge's neutrality, bias, and things like that. Okay, even outside of the courtroom. Okay, a judge may engage in extrajudicial activities except as prohibited by law or this code. However, when engaging in extrajudicial activities, a judge shall not participate in activities that would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. Okay, so these are outside activities that a judge is not allowed to participate in if a reasonable person would perceive them to undermine the judge's ability to be independent, whether it would affect the integrity of the judge or the judge's impartiality. Okay, so comment 3, it says discriminatory actions and expressions of bias or prejudice by a judge, even outside the judge's official or judicial action. So even if this is outside the courtroom, if this is in the neighborhood, if this is at a in a restaurant, Okay, so it says even outside the judge's official or judicial action, so in his personal life or her personal life, are likely to appear to a reasonable person to call into question the judge's integrity and impartiality. Examples include jokes or other remarks that demean individuals based on their, and we have the whole line up here. Okay, for the same reason, a judge's extrajudicial activities must not be conducted in connection or affiliation with an organization that practices invidious discrimination. Okay, so if you tell a joke or a remark off color that demeans somebody based upon these lists of characteristics, then you could be brought up for violating this rule. Okay. Also, a judge can affiliate with organizations that discriminate. Okay, so, for example, if the judge is Irish, can the judge affiliate or belong to an organization that promotes the Irish heritage? Well, the simple answer to that is yes, of course he can. Okay? And I think even if it's, membership in the organization is based on whether you have an Irish ancestry, I still think the judge can belong to that. Okay? Because it's not really invidious discrimination in that we're not accepting you because of this. It's basically an organization to promote a certain ancestry, a certain ethnicity, which is not invidious discrimination. Okay? Now, for example, if he was in an organization such as a golf club, and they wouldn't allow women in, well, that's invidious discrimination, because golfing doesn't promote an ethnicity, doesn't promote a heritage. Golfing is a sport which has nothing to do with the benign characteristics of people. It only has to do with hitting a golf ball. Okay? And I think the next comment says, a judge shall not hold membership in any organization that practices invidious discrimination on the basis of these characteristics. So, let's see. A judge shall not use the benefits or... Okay, let's just go up. Stay on A. So, like I said, where the Masters is played in Augusta, Georgia, the Augusta National Golf Course is the name of the golf club. Up until about 10 years ago, the club did not admit women into the club. Okay, it was an all-male club. A judge would not be able to belong to that club. All right. Now, I'm sure in the past, male judges did belong to that club. But as of now, that would be invidious discrimination because you're discriminating just based upon sex. It has nothing to do with the reason behind the club. Okay? Same thing if they would not allow a golf club, if they did not allow the Irish in. Okay? And there was a time in American history where they wouldn't let the Irish in. All right? B. A judge shall not use the benefits or facilities of an organization if the judge knows or should know that the organization practices invidious discrimination on one or more of the bases identified in paragraph A. A judge's attendance at an event in a facility of an organization a judge is not permitted to join is not a violation of this rule when the judge's attendance is an isolated event that could not reasonably be perceived as an endorsement of the organization's practices. Okay, so for example, suppose there was a dinner held at the Augusta National Golf Club, and the dinner was to raise money for the pro-life movement. Okay? And the judge was asked to speak at that event. Would he violate this rule And the answer would be no, because he was speaking at an event that was sponsored by a pro-life organization, and that pro-life organization was simply renting the facility for the dinner. Okay? And that is an isolated event. He's not necessarily using the benefits of the facilities. He's basically going there as an invitee by an organization that's using the benefits of that facility. All right? Okay. And an organization is generally said to discriminate invidiously if it arbitrarily excludes from membership on the basis of these characteristics. Whether an organization practices invidious discrimination is a complex question in which judges should be attentive. Okay? The answer cannot be determined from a mere examination of an organization's current membership rolls. So you can't say, hey, there's only white people in this organization. Well, if the organization has an open enrollment and only white people enroll, well, that's not discrimination. Okay? But rather depends upon how the organization selects members. So if it's not an open enrollment and it selects members only based on any of these invidious characteristics, as well as other such as whether the organization is dedicated to the preservation of religious, ethnic, or cultural values of legitimate common interest to its members, or whether it is an intimate, purely private organization whose membership limitations could not constitutionally be prohibited. Okay. I mentioned about the Irish ancestry group. That pretty much fits into what this comment is saying. Comment 4 is a judge's membership in a religious organization as a lawful exercise of the freedom of religion is not a violation of this rule. So that's very important, because a judge certainly can belong to a church, and a good church will discriminate against sin. And some of that sin today has now been written into law when it comes to the invidious characteristics of certain individuals. So, for example, if a judge goes to a church that does not believe in, believes only in the biblical marriage of one man and one woman, well, he is not in a discriminatory organization. Okay? Now, could someone say or perceive that as being bias or prejudice? Certainly they could. But, again, judges do not shed their constitutional rights at the courtroom door, or when they put on the robes, or when they're hired for the position. They have constitutional rights, and their exercise of freedom of exercise of religion is one of those. You can't say to a judge, just like you can't say to a doctor, you can't say to a plumber, hey, you can't go to this church because they believe things that we don't like. All right, well, that's none of your business. And one of the things that I like very much when it comes to people saying, oh, Christians just discriminate, they're prejudiced, all you need to answer to them is, hey, Jesus, my King, commands me to love my neighbor. Not only that, he commands me to love my enemy. Who are you commanded to love? Just an easy comeback. Okay. All right. Well, that's that. This is about 50 minutes. It's a long one. So everybody, God bless. I hope everybody is well.